And welcome back, Dean Obeidallah Show. We're live here Thursday, August 3rd. And people on hold, stick around. We're going to take some more calls right now. Very happy to welcome to the show someone I've interacted with on social media and emailed his organization, John Bonifaz. He is the constitutional attorney and co-founder and president of Free Speech for People. Also before that was executive director and general counsel of the National Voting Rights Institute. John, welcome to the show. Nice to have you on.
Thank you, Dean. Thanks for having me.
Sure. So first of all, your organization is doing so much work. Section 3, 14th Amendment. We'll get into that in a second. Tell people, though, because Free Speech for the People has been working to ensure people have a right to vote, getting big money out of politics and more. So to give your organization the due that it deserves, tell us a little bit the big picture, and then we'll really focus in on Section 3, 14th Amendment stuff.
Sure. Free Speech for People was launched on the day of the U.S. Supreme Court's ruling in Citizens United v. FEC in January of 2010. That, of course, was the ruling that equated corporations with people with political speech rights and unleashed this exponential rise in campaign spending by corporations spending from their general treasury funds. It swept away a century of precedent, barring corporations from spending money in our elections directly. And we launched Free Speech for People, focused on challenging big money in politics to overturn that ruling with a constitutional amendment campaign. We've been engaged in fighting to end foreign influence corporate spending across the country. We're fighting to protect the right to vote in our elections with a series of cases challenging voter suppression and voter intimidation across the country. We've been challenging corruption in government at all levels of government, including the highest levels of government. We were one of the first organizations to call for the impeachment of Donald Trump soon after he took the oath of office because of his violations of the emoluments clauses. And we're fighting to end disinformation and threats of violence on social media platforms when they're not held accountable for spreading that kind of disinformation, threats of violence.
That's great. And I imagine leading to 2024, there'll be even more work on social media. And, you know, just a short time ago, while it's not direct threats of violence, on Twitter for 3 days in a row, trending topics have been just openly anti-Semitic garbage. Like it's unreal, like tonight as well. And it just doesn't end. And that could lead, it's not direct calls for violence, but it's fostering hate and incitement against a religious minority group that could result in violence. So I can only imagine what 2024 has in store for us in social media.
Yeah, no, it's a very serious matter. These social media companies are effectively held not to be liable when they spread disinformation, threats of violence on their platforms. And we have a Big Tech Accountability Act that's designed to change that and make sure they're held accountable when they amplify these threats of violence and disinformation on their own platforms.
I agree. And so let's talk about Section 3 of the 14th Amendment and what the work of your organization has been. And could you remind people, Section 3 of the 14th Amendment, something we've discussed on the show a little, people have heard it in the media, to make sure everyone's on the same page, though. What's the essence of that section of the 14th Amendment?
So Section 3 of the 14th Amendment is designed to protect the Republic. It was enacted along with the rest of the 14th Amendment right after the Civil War. And it says very clearly that if you've taken an oath of office to defend the Constitution, and then you turn around and engage in insurrection, you're forever barred from holding public office again. And it initially focused on the ex-Confederates who had led the first insurrection in our nation's history, the Civil War, and had been in positions of power, having taken that oath to defend the Constitution and then turned around and engaged in that insurrection. But the framers of the 14th Amendment were clear that they were not only going to apply Section 3 of the 14th Amendment to those ex-Confederates, they were going to make it applicable to any future insurrection as well. That's clear in the legislative history. It's clear in the precedent that's been set. And now we have the second insurrection in our nation's history, January 6, 2021. And those who took an oath of office to defend the Constitution, including Donald Trump, and then turned around and engaged in insurrection, are forever barred from holding public office again.
So how do we execute that? Because there's not a self-executing measure. That you have Section 3 of the 14th Amendment, very clearly no person, a senator or representative or elector of president, VP, and you go through it, and they can't hold office if they've engaged in an insurrection. It says Congress can rectify it by a 2/3 vote, but how do we make this actually execute and work and do what it's supposed to do?
Yeah, it's a very important question, Dean. So we have launched this campaign right after the insurrection in June of 2021. We issued letters to every Secretary of State and chief election official across the country in all 50 states and the District of Columbia, making clear that if Donald Trump were to seek to be on their state ballots again, they were required under Section 3 of the 14th Amendment to bar him. Secretaries of State and chief election officials have a duty to determine that candidates who are seeking office meet the constitutional requirements for the office they seek if they want to be on that ballot. So if you're under the age of 35, if you're not a citizen of the United States, if you haven't been a resident for 14 months, all of those are disqualifications when you're trying to appear to be on the ballot running for president of the United States. But so too is Section 3 of the 14th Amendment a disqualification if you took an oath of office and then turned around and engaged in insurrection. So we're pressing secretaries of state and chief election officials all across the country to do their job, follow the mandate of Section 3 of the 14th Amendment, and bar Donald Trump from the ballot. And we're urging people to join us at trumpisdisqualified.org. We're joining this campaign with Me Familiar Vote to Education Fund, and we're working all across the country to press secretaries of state and chief election officials to do this. We've also been clear that while they have a duty to act, we also will act, and we will be filing in multiple states challenges to Trump's eligibility to appear on the ballot.
That's great. And as I mentioned to John online before, if you need a plaintiff in New York, where I live, I'm happy to volunteer, but New York is not one of the key states in all of this. Before we talk about the reaction of the Secretary of States, if you've heard anything, you touched on something very interesting. You mentioned that there are certain conditions in the Constitution to run for president, and born in the U.S., most namely, we know this one, 35 years of age. It's so important that people understand that this amendment is part of the Constitution. It's not like in certain states, they try to add a requirement that you have to give your tax returns. And in California, Supreme Court struck that down. They go, well, that's
Right.
not in the Constitution. You're adding a new condition. This is a constitutional condition. It's actually a constitutional disqualifier. So does that make it more persuasive?
Oh, absolutely. I mean, these are constitutional requirements for running for public office. And in particular with the 14th Amendment, Section 3, it applies to anyone who took an oath of office and then turned around and engaged in insurrection. But certainly it applies to Donald Trump, who led the insurrection, mobilized it, and facilitated it. And the other point that's worth highlighting, Dean, is no criminal indictment nor criminal conviction is necessary whatsoever to enforce Section 3 against Donald Trump. The historical precedent makes that clear. Legislative history of Section 3 of the 14th Amendment makes that clear. And the very text of the amendment makes that clear. The vast majority of ex-Confederates disqualified under Section 3 of the 14th Amendment never faced any charges for the crime that they committed of engaging in rebellion, but they were still disqualified under Section 3 of the 14th Amendment. So we need to wait for the Justice Department's trial of Donald Trump in this most recent indictment in order to enforce Section 3 of the 14th Amendment. In fact, we need to do it now in advance of the Republican primaries.
I couldn't agree with you more. I'm chatting with John Bonifaz, constitutional attorney and co-founder and president of Free Speech for People. So have you sent letters to all 50 states, or have you targeted certain states? And if you did, why did you target those states?
Well, we initially in June of 2021 sent letters to all 50 states and the District of Columbia, and no state is absolved of their responsibility from complying with the mandate Section 3 of the 14th Amendment. However, we have updated letters to certain key states, including Nevada, Colorado, California, Massachusetts, and elsewhere. And we are making clear to those secretaries that they have a duty to act. Now, some have said they're looking at the question. You know, the Colorado Secretary of State's office publicly responded saying they're reviewing the letter and they're not able to comment on how they will act. Others have responded, at least in the case of Massachusetts Secretary of State, in a way that is contrary to what the law says. The Massachusetts Secretary of State, Bill Galvin, has publicly stated that a criminal conviction is needed before he can enforce Section 3 of the 14th Amendment. So this is where the public comes in. We, the people, need to pressure our secretaries of state and chief election officials to carry out their solemn duty here, their responsibility to enforce this constitutional provision. If they don't, then they're ultimately not carrying out their own oath of office. They're required to enforce Section 3 of the 14th Amendment, just as they'd be required if a 20-year-old were seeking to run for president of the United States. My daughter, Dean, is 16. I think she'd make a great candidate for president of the United States. But you know what?
Right.
She's barred from being on any state ballot in the country because she's not yet of the age. And just like any secretary would bar her from the ballot, so too does Donald Trump need to be barred from the ballot.
I agree with you 100%. You mentioned the potential litigation. Do you have any deadlines in that when you will file lawsuits? And if you do, when? And is there an order of states that you're going to file in?
So we're not able to reveal to Donald Trump and his team what our plans
listens to the
are.
show, but I understand.
Right. But I can tell you that it will be in multiple states, and I can tell you that the evidence, as we already know, is overwhelming. That he engaged in this insurrection, that he led, mobilized, and facilitated it. And the indictment that the Justice Department just issued supports all of that. They make clear that he exploited the violence on Capitol Hill that day to try to overturn the 2020 election, in full knowledge that his vice president was facing threats of being hung there on the Capitol. And he went ahead and tweeted out Mike Pence didn't do the right thing. He was engaged in that insurrection. There's no question about it. And that evidence will be put forward before all the proceedings where we file these legal actions to challenge his eligibility.
I covered this once on the show maybe a year ago, and I wrote about it for MSNBC, and I think I quoted your organization. It was the case in New Mexico, borrowing the head of the Cowboys for Trump, co-founder and former county commissioner Couey Griffin. And a court there had a hearing, a few-day trial, and found he violated Section 3 of the 14th Amendment. And just last year, the Supreme Court of New Mexico would not overturn it. They're not going to hear it. So this guy is gone. And I know it's not controlling, but have you looked at that case, and do you find the reasoning persuasive in making other similar arguments in other cases?
Yes, it's a very important case. It was brought by our ally crew, Citizens for Responsibility and Ethics in Washington, and others in New Mexico. And we certainly will rely on that precedent. We also rely on the precedent that we set at Free Speech for People in two other cases prior to the New Mexico case. One was the Madison Cawthorn case, where we challenged his eligibility in North Carolina to be on the ballot, and Marjorie Taylor Greene's case in Georgia. In both of those cases, we won federal court precedent that makes clear that Section 3 of the 14th Amendment applies to modern day insurrectionists, and that states have the authority to enforce it. And in fact, the New Mexico ruling built on the ruling that we had in the Georgia case, which made clear that states have the authority to enforce Section 3 of the 14th Amendment, and that no criminal conviction is necessary to carry out that enforcement. So that's been established now, that case and in the Mexico case, and will be an important precedent that we apply for our challenges to Donald Trump.
And I'm sure people now, that probably rings a bell in their mind, the Marjorie Taylor Greene case, she actually had to testify, and it was the Free Speech for People that brought that lawsuit to try to disqualify her. Can you remind people what happened, and was it relevant, the fact that she was not, I don't believe she was a member of Congress in the lead up. She was a congressperson elect, and then she gets sworn in right before January 6th, if I remember correctly.
Correct. So she
January 3rd, but
that's right. So her actions that were under scrutiny were largely the actions starting on January 3rd, but she also had, leading up to the insurrection, been making statements such as, the transfer of power shall not happen peacefully, and making clear that she was putting code words out there like this is our 1776 moment, that were calls for violence. Now, when she took the stand for 3 hours, first time a member of Congress has been forced to testify under oath about the role they played in insurrection, she claimed to not remember anything for those 3 hours. She didn't remember anything about what she had said on social media, what she had done leading up to the insurrection. She just claimed, not to recall. And that was an example of her being completely evasive. But the evidence against Donald Trump is even more overwhelming than it was against Marjorie Taylor Greene. We know that he called everyone to Washington, D.C. on January 6th. He said it would be wild. He urged them to show up. And then at the ellipse, he made clear that they needed to march down to the Capitol. And then he, as I said before, during the insurrection, he kept it going. He encouraged it via his social media action. So this is a exhibit A, really, Dean, of somebody who is disqualified under Section 3 of the 14th Amendment. And if we don't enforce it, then really we're saying it's a dead letter in the Constitution, that we're ignoring entirely that constitutional mandate. We can't let that happen at this moment in our history.
True. And going back to Marjorie Taylor Greene, can you remind us what was the reasoning of the court that in finding that she didn't violate Section 3 of the 14th Amendment and she wouldn't be banned? I know it's vastly different than Donald Trump's case. I was just curious if you recall.
Yeah, no, the judge basically found that she had not engaged in insurrection, but he also did not look at her testimony as being incredible, meaning that not truthworthy. He actually took that testimony as a given, treated it as credible, and that I think was a huge error in his ruling. If you take a look at what she had said in her statements and all that had come before that trial, that hearing, and then you looked at her evasiveness on the stand, you could not look at her testimony as credible. But he took it that as credible, and then he found there was not enough evidence to prove she had engaged in insurrection.
In the January 6th report, there's no member of Congress more discussed for his actions than Jim Jordan. The report concludes he's, quote, a significant player in the effort of Donald Trump to overturn the election. Their words were significant player. And they went through in great detail. Jim Jordan didn't just speak. He led conference calls with Trump and other leaders. He was on January 6th speaking to people. Is there any contemplation to look at Jim Jordan and try to use Section 3 of the 14th Amendment against him in Ohio?
Well, I think we have to look at the question from the standpoint, did he engage in insurrection? I think that trying to challenge the election in other ways doesn't necessarily amount to engaging in the insurrection, but there may very well be more evidence to uncover that shows that Jim Jordan was supportive of what was happening that day at the Capitol. But certainly with Donald Trump, we know that he was encouraging that very insurrection. So if you were a member of Congress, for example, Dean, who voted to block the votes from Ohio or Arizona or another state, that doesn't rise to the level of engaging in insurrection. But what does rise to the level of engaging in insurrection is all the actions that Donald Trump took that led to the violence that day.
And just so it's very specific for everyone, and because you're a constitutional attorney, that when we're talking insurrection, what Trump is charged with now, and it doesn't, I'm not getting to that you need any convictions, just so people understand there's two different buckets here. Trump behind the scenes, pressuring Mike Pence, pressuring DOJ officials, just say the election's corrupt, leave the rest to me. That's not insurrection. Those are different crimes. The insurrection you look at, and the one that you believe Section 3, 14th Amendment applies to, is the actual attack on January 6th. That's the only part of it, just to be clear?
Well, what I'm saying is the fact that Donald Trump incited and mobilized and facilitated that insurrection then gives ground to look at everything else he did to try to overturn the election. So all that's going to be brought in to our challenge to Donald Trump. But if you only engaged in trying to, overturn the election through voting on the floor of the Senate or House, blocking the certification of the vote of certain states, and you then took no action with respect to the insurrection, then that evidence doesn't apply. But we will certainly argue that if you take the totality of the evidence that against Donald Trump, everything he did leading up to the insurrection and then during the insurrection, all amounts to him having given aid and comfort to the insurrection and having engaged in it.
How important, if we look in the big picture now, we had Donald Trump arraigned today on the 4 felonies he's charged with related to January 6th. How important is that in the idea of protecting our democratic republic going forward, that he's charged and hopefully will be held accountable?
Well, we're at a critical crossroads, Dean. I mean, either he's held accountable for the crimes he's committed, or we're going down a road toward tyranny. That really is not designed to be any, more rhetorical or anything like that. But this is the reality we face, because here is someone who so defied the rule of law, so defied our Constitution and the basic principles of our democracy to try to overturn a legitimate election because he didn't like the results which found he had lost, and then engaged in this rogue power and this misuse of power. If he's not held accountable, it's a very dangerous moment for our nation. But he doesn't only need to be held accountable via the criminal justice process. He also needs to face accountability via Section 3 of the 14th Amendment. He cannot be allowed to be on the ballot again when he is so clearly disqualified because of his actions.
You know, I don't really care what the reaction would be, but are you concerned about if he's disqualified in certain states, how he and maybe even some of his supporters react?
Well, we expect that Donald Trump, if he's disqualified, will challenge it in court and
Right.
and appeal it. And we're prepared to defend any ruling that finds he's disqualified. And he's entitled to that due process. He's entitled to those appeals. That I think will be a legitimate reaction if he wants to engage in those appeals. He's got that right. But you know, we're not going to be dealing with the fear of what else could be done in a legal way to not enforce this critical provision of the Constitution. If we do that, we might as well just give up on our democracy and our Constitution. We can't let mob violence or the threats of mob violence prevent us from enforcing the rule of law and enforcing this critical provision of the Constitution.
I certainly applaud you for that. And that's the way. This is a time for you've got to stand up and be counted and use all of our skill set to protect our democratic republic. And, you know, I was mentioning earlier, I'm reading Ron Chernow's book on George Washington and what George Washington went through and what the revolutionaries and what these people have a dream of self-determination to get away from a monarchy where they can have their own voice heard and their votes counted and matter. And
yes,
to have an experiment unlike that the world had seen is existed for 200 plus years. And we can't allow it to end because of Donald Trump. And these are the stakes. And I really wish Democrats would speak, members of it, some do, but most do more like in kind of measured tones. This is it.
This is it.
This is the line in the sand. This is right here. This is the fight of this generation to save our democracy, the same way the greatest generation fought fascists overseas. We have it here. And the lucky is we don't have to wage a war. We can just do it through voting and engaging in legal means. We just can't be lazy. We just can't think that we can't have an impact. We have to believe and we can make a difference on this.
Well said, Dean. I totally agree. And it's a time to stand up like no other to defend our democracy and our Constitution. And that's why, you know, people all across the country have a role to play in pressuring their Secretary of State, their chief election official, to visit us at trumpisdisqualified.org, to sign our petition, and to join us in calling on their Secretary of State to enforce this critical constitutional mandate and bar Donald Trump from the ballot.
Trumpisdisqualified.com. Check it out. You know, we have on the Secretary of State of Arizona, Adrian Fontes, on a lot. We're going to talk next time. This is going to be on our list. I'm not kidding. We had him on a candidate. We've had him on a few times since. A really good guy. And to talk about it, if I'm sure he's gotten a letter from your organization to see, he's very serious about this stuff. He's serving the Marines. He understands, and he's a lawyer as well. He understands this is a fight for our democracy, but I think he'll do it whatever is the right move from his point of view and looking at the law and everything. But John, thanks so much for being on. You guys are doing great work at Free Speech for the People. And again, it's DonaldTrumpisDisqualified.com. That's the website.
TrumpisDisqualified.org. Yeah, but you .com.
TrumpisDisqualified.org.